All right. Hello, everybody out there in the world, and welcome to our COVID-19 webinar. This is, I think, what is this, Eric?
22.
22 in a series that we've been doing
Counting.
since COVID broke out. And this one is on the vaccines. And when something goes wrong with the vaccine, when is it work related and when isn't it? And it's also about what it means if an employer mandates or encourages someone getting a vaccine and things go wrong. So actually, Christine Gerbasi started this topic with us a couple of weeks ago. She asked a question and I thought, well, this won't make a webinar. This is just a very simple question. But once again, I underestimated the complexity of the kind of issues that are arising surrounding workers' comp and COVID. So I asked Christine to join us and she graciously did. It's going to be great because Christine can ask all the questions that she's encountering from her clients and working at Keenan, and sort of give us the on the ground questions that are arising and the practical realities. And so thanks for joining us, Christine.
Thanks for having me.
Yeah, we got the usual cast of characters here. In addition, Christine's a VP of Property and Casualty at Keenan. And there's me, Mike Sullivan, and there's Eric, the managing partner in charge of our employment law section. Hi, Eric.
Hey, everybody.
Digging the bow tie, Eric. Hey, how come you don't have the bow tie on in the standard picture we put on?
You know, it's a failing on my part, and it's also me really wanting to get rid of that picture. So it's
way to own your part in it.
What's that? Oh my!
That's really good. So before we get started, just to tell you who we are. So I'm the general managing partner of Michael Sullivan and Associates, which is a defense firm. We have, I think, last count, 85 lawyers in 9 offices throughout the state. It's pretty cool. We don't just do workers' comp either. Eric is the managing partner for our employment law section. And we have other sections too, do a lot of different stuff. But I'm also the author of Sullivan on Comp. And if you're listening to this, you're probably a subscriber. This is a production of Sullivan on Comp, which is a comprehensive treatise that covers all of workers' comp law in California. It's like 15 volumes. It's just ridiculous. It's really long. It's a reference book. And it's a website with all kinds of tools. And so anyway, we put on a lot of webinars with Sullivan on Comp. And when I do, I wear my neutral hat. I don't try and advocate for the defense like my normal defense attorney self would. I'm trying to explore all the issues and all the different sides of what the different people might think about it. Now, Eric, of course, remains
a neutral hat.
Yeah, you don't have a rabid defense attorney in a bow tie at all times.
Always.
So, yeah. So anyway, this is a production of Sullivan on Comp. It's being made available to the whole world. We're not normally it's behind the paywall, but we haven't been doing that with these COVID webinars because we just think the world needs to know. So we're just putting it out there for everybody. Tell us about Keenan, Christine, since you're from Keenan.
Thank you, Mike and Eric. So Keenan is an insurance and financial solution organization. We work with schools, public agencies, and healthcare organizations. We were founded in 1972, so we're celebrating our 49th year this year. We joined Assured Partners in 2017, and we're the 11th largest insurance broker in the United States. So we have over 750 employees statewide, 9 offices. And we provide property casualty, workers' compensation, employee benefits, and financial services.
Wow, that's a big Twinkie. You got a lot of employees and more than
we
me.
do.
Yeah. And 850 school districts, 120 public agencies, and 100 healthcare organization clinics. So are you getting any questions, Christine?
They are asking questions every single day, all day long. So we really appreciate you guys putting this webinar together and letting me share some of those questions that we're getting and hopefully walk away with a lot of answers today.
Yeah, hopefully, or just more
questions.
No, we got some answers. We got some answers for you.
We'll try and stray away from it depends as much as we can.
Like I said, this is part of a series. So this and the next slide are a listing of all the webinars we've done so far, which we tried to cover just about everything. You can see it: psychiatric injuries, work-related, return to work, liability for temporary disability claim form. And we just kept going, issues in litigation, we've had the doctor on a couple of times to talk about the medical issues and the vaccine at the end of last year. Notices, Cal OSHA's, we have AB 685, right, with notification requirements and reporting requirements. And we had SB 1159 and the presumption, right? And then we have the new Cal OSHA regulation. It just goes on and on, never stops. Probably not going to stop for the rest of the year. So we're probably going to hearing from us a lot.
Might be good to watch the chapter 21, part 21 in tandem, because the doctor went into a lot of great detail about the vaccine, that we didn't know about, and answered questions on that. But just so you know, when we recorded that one, it was before the EEOC came out with their new guidelines. We didn't have that yet, so watching them in tandem is probably a good idea.
Yeah, check out the last one too, because he's right. We had the doctor on and we talked all about the vaccine, and how it works or doesn't work and where it came from and what the risks are and what people are saying about it. And this is a vaccine webinar too. So I also wanted to mention, this is our book that we put together. It's an ebook, so we're not printing it, but if we print it, I think Eric said it'd be 350 pages long. We're updating it every day, and we're trying to answer every question that there is about COVID with employment law and workers' comp. It's written in plain speak. It's always up to date. You can download it for free. Just go to our website and you can bookmark it. And we're having thousands and thousands of people hit it all the time. So hopefully, if you don't have it, you can make it of use to you. And that's all the advertising I have for today. I'm done with the advertising and the introducing. So what we are going to talk about today is, okay, we have the vaccines are here. So what happens when there's an injury from a vaccine? That's the question. Because, like millions and millions of people, I saw the new president say they're trying to inoculate 100 million people in the next 100 days. And in California, we've moved to another time. Thank you. Sorry. Yeah, I mean, in California, the healthcare workers are all getting vaccinated now. People over 65 are getting vaccinated. And I don't know. I don't think we're going to get ours till maybe April or May. But if you're under 65 and you don't have any significant comorbidities, being chronically good looking doesn't count, Eric, as a comorbidity. So it's something you and I are just going to have to.
Wow. I'm sorry, Christine, you have to vote up with that.
Anyway, so what happens? Well, there's some rules about healthcare organizations, and there's actually some special rules about that we'll talk about. But what about all the other employers? Under what circumstances can an injury from a vaccine be considered work-related? That's a question. And then Christine raised a good question, which I hadn't thought of, which has to do with exclusive remedy. And what happens? Can the employer be acting in a dual capacity if they're a doctor? So that we're going to talk about that. And then Eric's going to talk a lot about mandating vaccines. Like, can employers mandate vaccines? Should they? What about encouraging them? What are the limits of what the employer can and can't do? Because, a lot of employers are trying to make decisions as to their policies here, right? With imperfect guidance from the law. So that's what we're going to cover. And then Christine is going to jump in and ask us questions. I had some notes
to try to stump the panel.
Yeah, stump the panel. We were talking before the presentation, and you asked a couple of questions. I had to go look in the law. So
yeah, I mean, we're getting questions every day. I mean, healthcare organizations, they're in their second wave of the vaccine. They're having adverse reactions. We're starting to see claims come in. We've got other employees gearing up, like you said, for the next wave of the vaccine, and they have just a ton of questions around workers' compensation exposure and the pros and cons of mandating. And so all of these topics, I think, are just going to be really helpful today.
What kind of adverse reactions are you seeing?
So, right now, thankfully, it appears to be minor. It's the arm is sore. Maybe they're having a rash at the inoculation site. They're having the flu-like symptoms. And so, those questions come up. If it's something beyond first aid, what obligation is there in terms of providing workers' compensation, benefits? And of course, that led to the exclusive remedy question that I sent over, to you and Eric, because employers are also worried about, can they be sued civilly? If there's an allegation of negligence and how that vaccine was administered. So we're grappling with all those issues.
What kind of employers might want to actually give vaccines to their people other than healthcare organizations?
So, school districts, which, we work with many, as we stated earlier, they've got school nurses on site, many school nurses within a district. So there's a lot of discussion about having their school nurses administer the vaccine. We've got the county office of education actually asking school districts, I think maybe to kind of get the vaccines, administered as quickly as possible and get this rollout done. That's a good source, to start getting people inoculated.
That's interesting.
So if you have a school nurse that administers that vaccine and something goes wrong, what kind of liability do, schools need to think about, and what can they do to maybe to mitigate that liability?
Well, that's interesting because in the case of a school district, they might be inoculating a co-employee, but they might be inoculating a student, which wouldn't be workers' comp.
Correct.
Right.
Correct.
Yeah.
And if they're inoculating an employee, there's HIPAA. We think about HIPAA and, what information can they know about that employee they're inoculating, what medical history, so there's just so many things that it's kind of an onion, you keep peeling it back and there's more and more and more questions that get asked.
Right.
Okay. Yeah, that's true. We're going to talk about that, like the pre-screening and Eric's part. I wonder what kind of employers what kind of employer might be inclined to just, because an employer could just stay out of it, right? They could just say, okay, well, people are getting vaccines. It's interesting to me to think about it as an employer myself, what kinds of employers would want to mandate it or encourage it?
Yeah, I'm personally not hearing of any of our clients that are mandating it. I don't know that I would say they were encouraging it. They're making it available. I think for school districts, under, the Safe School Reopening Plan, it talks a lot about administering the vaccines. And then I think for our economy to open back up, we've got to flatten the curve one way or another. And vaccines are certainly a way to accomplish that. So
yeah, as I understand it, it's not yet demonstrated that getting the vaccine stops you from being a spreader. I mean, normally I think if someone has gotten a vaccine with a virus, you think of that person as not being able to give you the virus. Right. And that's probably the case, if I recall correctly from talking to the doctor. I think in my mind, I'm thinking, yeah, if you do the vaccine, you probably can't infect someone else, but they don't know that.
Right.
Right. So if I'm an employer, I might want to say, hey, no one comes back to work until they can show me a piece of paper with a vaccine. So because otherwise you might infect others, but I don't even know if that's good thinking or not.
Yeah, that's one of the things we learned talking to the doctor. And I think there was an assumption going into that, even for me, that, hey, if people, vaccinated or if they've had it already, they shouldn't be able to spread it. That's part of the perk of why we're doing this. And one of the issues with having an emergency use authorization vaccine, which this is, and that is unprecedented because we're in an emergency situation, it's not well tested. So there isn't data out there that says it can't be spread. There is some assumption that it would be limited because what the vaccine does is prevents the virus from getting into healthy cells. So it won't be able to get in there and spread through the body, but it could still be on the body and in the nasal cavity and somebody sneezes. So we don't really know.
Yeah, we don't know. We don't think, but we don't, I was thinking like, what if I was a dentist and I was having people coming in all the time? I would want my people to get vaccinated just because I would think there'd be a greater chance they couldn't infect others. And I would know that they couldn't get sick from people coming in. So that I can see why there's a lot of business. Now, the more I think about it, the more I think of how compelling it is for businesses. There's business reasons for wanting to get everyone vaccinated or encouraging it, at least, even if you don't mandate it. Anyway, I guess we'll see about it. I was looking at some numbers, in California, where we're reaching 3 million. The news today was that the latest surge has subsided somewhat the last day or two. It's gone down, but we've had 34,000 deaths in California. In the United States, we're headed for 400,000. Someone said, to put that in perspective, 500,000 Americans died of World War II. So it's pretty bad. I think 1 in 10 people here in LA have it or have had it. So it's gotten pretty bad. It's interesting that not everyone has faith in the vaccines. I looked up, there's an article about this in the LA Times recently, and they made reference that 27% of Americans are what they call hesitant, meaning they wouldn't take it, at least not in the first group, right? And even more than that, 29% of healthcare workers are hesitant, which is, saying something, because presumably they have more expertise or access to more expertise generally than the average person. And other things I saw that were interesting were there was this Public Policy Institute of California looked at the different races, and they said that 69% of Black people are hesitant, whereas only 35% of white people are. And 43% of Latinos are hesitant because of, the history of abuse of the minorities with government administered and privately administered vaccinations and other types of healthcare. So that really says something. And then if indeed if they're distributed correctly and they work, then this pandemic could continue to fall disproportionately on minorities. And here's another one. 42% of Republicans are hesitant. 12% of Democrats are hesitant. Which I don't know, but it might have something to do with mistrust of government. So anyway, that's what's going on out there, but it's not stopping the vaccines from happening in droves. We've seen all the initiatives by Gavin Newsom and the new president, Biden, to really get out there as aggressively as they can. It's interesting that they're only approved on an emergency basis, right, Eric? This right. EAU. And we talked about it in the last webinar. So that means that right now it's all approved, but eventually they're going to have to go through the regular process and get approved, outside the scope of an emergency.
Right. Like any other FDA drug, because neither of these that are out, the Moderna or the Pfizer, have gone through all of those rigors and tests. Women who are pregnant, women trying to get pregnant, certain age groups. So the vast, testing that's typically done has not. And the assumption is, they're trying to go through the regular process as we're doing this in an emergency use basis. Mm-hmm. But, usually that takes quite a long time.
Yeah. I think the healthcare organizations, you can confirm or deny this, Christine, but almost all of them are inoculating their own people.
They are, and on a voluntary basis. And from our clients, they're really starting in that second phase. So they're just about done with that phase.
Yeah. But they're not doing it. It's not compelled.
Correct.
Even though, arguably, if they're not inoculated, there could be more danger of infection or spread because they're treating COVID people.
Correct.
COVID. Yeah. That's saying something, huh?
Yeah, but I don't think they, for the most part, mandated like even the flu vaccine. So I think they're kind of taking a similar approach from a policy perspective. Right. And if their employees don't get the flu or the COVID vaccine, then, they have to continue to wear a mask and do other, safeguards.
Okay. So anyway, people want to know, it's like, if you get injured from a vaccine, then is it compensable? And the rule in workers' comp generally is that if you get a compensable consequence of an injury, then it's compensable. But usually those rules are all about like, okay, I got injured, my back got hurt, and now I got fat and I got gout, or my back got hurt and now I'm stressed out, or I'm addicted to medication, or I got psychological injuries, right? Compensable consequences. There can also be, we have a whole chapter in it in Sullivan Comp. I forgot to say that we're at the bottom of each slide, I put the section on Sullivan Comp that pertains. So if you want to read about it in greater depth, you can just go there. if you're a subscriber, which you almost certainly are if you're listening to this. But anyway, so, you know, or you could be, there's compensable consequences from getting medical treatment. Like if you're on your way to a doctor's office to get treatment and you get in a car accident, well, that's work related. It relates back to the original injury, but that's not what we're really talking about here, right? This isn't a compensable consequence. This is sort of a preventative medicine. So this is an independent event when the employer is providing, encouraging, or assisting or allowing you to get a vaccine. To what extent does a preventive medicine apply? And there's law on it, and I'm gonna go through it. There's just a couple of cases on it so far. I forgot to mention, you know, we put out a paper on this, right? I mean, actually, Christine, you ruined my weekend. Not last weekend, but the weekend before, because you asked the questions and I was like, oh, and I wrote a little paper on it, and then I sent it to Eric and my co-author, Sure Logan. They said, no, you're wrong. And it turns out I was wrong. And then I sent you the paper and you're like, hey, you forgot about all these other issues. And so I was wrong again. And I rewrite it. I had to rewrite the dang thing like 5 times.
It was very helpful though. Thank you.
Yeah. Of course, with COVID, what was I doing on the weekend anyway? It's not like I was going out clubbing,
right.
You know? So anyway, so here's how it works. You know, when I was writing Sullivan on Comp, there was a section 5.2. It's a very specific law. And after I wrote that section, and it was one of the first things I did. So it must have been about 2005. I forgot about this section until now. Okay. Because it was never relevant to anything. But what it fundamentally says is that if you are a healthcare worker and you work for a healthcare organization and they inoculate you and you get injured, it's compensable. It's a very particular section. It only applies to healthcare organizations and healthcare workers. It says an injury is defined as including a reaction or a side effect of preventative health care. So an example might be adverse reaction to a flu shot. These are actual cases. There's only a couple of cases that have arisen under this particular statute. An adverse reaction to a flu shot or an injury from a treadmill at an employer-required health checkup. So, I mean, a vaccination would certainly fall within this. Now, let me go back. What is a healthcare worker? Well, it's pretty broadly defined. It's in the Civil Code 56.05, registered nurse, vocational nurse, certified nurses, NAID, clinical laboratory technologist, dental hygienist, physician, janitor, and housekeeping worker on a healthcare facility. Right now, it doesn't include administrative staff, so it doesn't necessarily mean everybody is working there, but it's just about everybody, right? Anyone's doing the healthcare stuff. And what's a healthcare? Well, it's interesting. What is an employer that provides healthcare services? Well, they're primarily engaged in the business of healthcare. That's all they give us, which is interesting because healthcare providers are defined so specifically in the other statutory schemes we've been reviewing regarding COVID so far. Anyway, it doesn't if you're not in the business of primarily providing healthcare, then you don't count. So if you're an employee, if your employee inoculates you and it's not primarily an employer that provides healthcare, then this statute wouldn't count. They got to be primarily providing healthcare. It's got to be, and they have to be providing it to their own employees who are healthcare workers. So anyway, that's that one. But what about all the other employers in the world? Because this isn't going to be most of the employers. Right. I mean, or what about, that are inoculating their people, like you said, the nurses. School's not primarily providing healthcare, right? So it wouldn't fall in here. So what about all the other employers in the world? Well, there's a couple of cases that have come out on this, and one's a Court of Appeals case and one's a California Supreme Court case. And they are, they seem to conclude generally that it's going to be work related if it's linked to work, certainly if the employer mandates it, and depending on the degree to which the employer benefits or the employer encourages it, they will be considered work related. So in Roberts versus USO camp shows, okay, there's an employee who was a musician and the employer says, you have to get these vaccinations to do your job. And he got encephalitis, which isn't good. It kind of makes me wonder, like, what can go wrong with a vaccine? Like, what are we even talking about? I mean, Christine, you haven't really seen it. But in the next case, we'll look at what happened is a partial paralysis of the right arm from the vaccine. There was, in this one, it's encephalitis. There are allergic reactions to vaccines, and there can be comorbidities that don't do well with vaccines. So it seems like it's probably a pretty rare event. Christine, you talked about, I'm kind of getting off track on the case, but I wanted to mention this. You talked a little bit about the reactions to vaccines we're seeing so far. Eric, you were mentioning earlier that people seem to have symptoms after they get a vaccine.
Yeah. Before we started the Zoom, we were talking about that, and I know many people who've already started getting the vaccines and the second vaccine. And Christine, you probably have more, feedback than I have, but everybody that I know that has done it, and many of them in the healthcare area, after the second vaccine, they had, flu-like symptoms for 24 hours, and, body aches, fever, all of those things that are flu-like symptoms, which was expected when this was rolling out. We even talked about that at the last webinar, that was expected, and that's what we're seeing. So,
and while those might be minor for the most part in nature, some of the questions that we're getting, which we've talked about a little bit before this webinar, is under 1159, if it's a COVID case, right? The waiting period is waived for temporary disability. And so the question comes up, if there's a reaction to the vaccine and they need time off as a result, a day, 2 days, or 3 days, is temporary disability going to be due and payable if it's a compensable injury, or does that waiting period, no longer apply, similar to 1159? So they might be more minor claims in nature, but there could be a period of lost time. There could be some medical care. So it could incur, claims and costs associated with those claims.
There's a couple of questions in my mind. One is, do you have to provide a claim form?
That's a big question.
Yeah, people are reacting to a vaccination. I think the answer is predominantly no, because they fall within the auspices of first aid. And then secondly, claim forms only have to be provided when you know that someone has a work-related injury, right? Injury is something beyond first aid. So I'd say in almost all the cases, no. So it doesn't have to, you get a claim form, you get a claim form, you get a claim form, You don't have to have a tennis machine shooting out claim forms to all your employees to have some reaction to a vaccine.
Yeah. So what are your thoughts on the temporary disability, though? If there is a claim and somebody is losing time, would that 3-day waiting period apply for temporary disability?
Yeah, we talked about this. I think what we talked about before we started was, does 1159 apply to these cases, right? Because that's when the temporary disability waiting period would go away. I don't think it does. You asked me this question right before we got started, and I looked it up. And at first I thought, oh, well, maybe it does. And then you pointed out that I was wrong again. So I appreciate it. I've never been so wrong all the time, but I get it right before I talk to the public. That's the important thing. But it says the term injury, if you look at 3212.88, and the other 87 and 86 also follow suit, right? It defines injury as an illness or death resulted from COVID-19, but only if all the following circumstances apply. One of them is a test positive for COVID-19. So an injury from a vaccination 1159 wouldn't apply to that, I don't think. No. Anyway, we're off topic, but I thought those were interesting points. I wanted to bring them out. So here comes Roberts, and we get a musician. He gets encephalitis, and he says, "I'm injured on the job." And the employer says, "No, you're not. This doesn't count. You got it before you started working here, and it doesn't have anything to do with work anyway." And the Court of Appeals reversed and said, incapacity caused by illness or inoculation may be properly found to have arisen out of employment where the treatment is submitted to pursuant to the direction or for the benefit of the employer. Okay, So that's that. And then along comes Maher versus WC. It was a big case on this. It was a California Supreme Court case in 1983. And in this case, the nurse applied to work at a hospital, and there was a mandatory test for tuberculosis. And they found it, they treated her, and she got injured. So it went back to that test for tuberculosis, which was a requirement of working at the employer. Note in both of these cases, there was a requirement by the employer that they undergo the testing, which in this case equates to the vaccination, right? So that's interesting. But they had this language, the rule, they found it was work-related. And they said the rule is well settled that where an employee submits to inoculation or vaccination at the direction of the employer and for the employer's benefit, an injury resulting therefrom is compensable. So you know what? I thought it was interesting because the prior case said if it happens at the direction of the employer or for the employer's benefit. The Supreme Court misread the case evidently and said the rule is if it's at the direction of the employer and for the employer's benefit, not or, but and, right? So that was pretty interesting. But the thing about Maher is it went on to use a different line of reasoning altogether, and they linked causation between employment and the inoculation. When there's a link there, was a causal relationship. That was how you determine whether it's work related or not. They said, look, if you are an employee and you're getting the inoculation because of your employment, then there's a link, there's a causal link between the employment and the inoculation, and that makes it work related. And the thing about workers' comp that everyone knows is that it doesn't have to be a sole cause. It can just be a concurrent cause. We're all familiar with the 1% rule, right? There's no apportioning of medical care. If it's at all related to work, then that's a sufficient cause. And that what this case said is it doesn't have to be the sole cause. Employment doesn't have to be the sole cause to get the inoculation. It can just be a concurrent cause. It can be a cause, one of the causes. So if you can link the employment to the inoculation, it's work related. And they had this quote here: if it had not been for the exigencies of the employment, the employee would not have taken that test. So they seem to be setting out a pretty light standard for linking inoculation and its ill effects if they have them to the work. I mean, look, to some extent, an inoculation is always going to benefit the employer because their employees aren't sick and can't get sick, right? So, I mean, it seems like it's not going to take much to have it be work related.
Yeah. I wanted to ask real quick, Mike, you were talking about some of these transitory type of symptoms like flu-like symptoms, fever, body aches, that kind of thing. You know, since that is what, you know, is mostly being reported, you think that falls under the first aid category?
Yes. Yeah, it does.
Now and I was looking at the Q&A, and there's a good question in here because we also talked about this at the last vaccine webinar. Is there, you know, were some mentions anyway in the news that it could be linked to Guillain-Barré, which is a, you know, pretty serious illness. So I just wanted to, you know, touch on that because it was in the Q&A and it's a more serious illness. What we know about that, what we heard from the doctor was that the reports of the link, which were, I mean, there was also reports of that with the flu vaccine as well. But those studies, according to the doctor we talked to who had worked with Pfizer, were not well done. And there was more recent studies that indicated there's very little support that Guillain-Barré was linked to it. And I looked into this myself because my dad had Guillain-Barré in the 90s, and it's most, you know, certainly serious. He was, you know, couldn't move at all for 6 months. So, you know, there's, you know, serious consequences to that illness. But I think the link between those has been, it seems to be very slim from what I've seen. And the studies have been rebutted that did come out on that.
Well, that's good. You got to think that there's going to be some adverse reaction to a vaccine, given the amount that we're having. Everyone's getting it. Even if it's 1/2 of 1% or less, it's going to be a lot of people.
Right.
And it just, it will get beyond first aid in some cases. And that's when you have to think about whether you have to provide a claim form or not. But remember, you got to know it's work related to have to provide a claim form. Do you know that? Well, maybe you do. But anyway, the employers will have to think about the provision of the claim form where it gets beyond first aid. I just think that employers don't want to be just standing by the vaccination desk with the claim form, because everyone's going to have some reaction.
Mhm.
And we don't need that. It's not appropriate or proper that a claim form be given or filed.
Yep.
Yeah. So anyway, okay. So what do we conclude from these cases? Well, we concluded it will be compensable if the employer requires a vaccination for return to work. Okay. No coming back to work, acquire a vaccination. You get injured from vaccination, it's work related. Same thing if the employer requires you. I've been working from home, right? You see my pictures behind me of my loving family. Yeah. I'm working at home and everyone's working at home, like almost everybody. So what if I said, okay, you can't come back into the office. You can still be an employee, but you can't come back to the office unless you get a vaccination, work related, if there's an injury from the vaccination. If, as we said with that special weird statute, right? If you're a healthcare organization providing an inoculation to healthcare workers in your organization, it's work related. So we know that. It gets a little slippery as you go down the level of involvement of the employer, as you start to get into questions of whether or not the employee, whether there's a link between the employment and the inoculation. The weaker the link, the harder it gets. So if you have a non-HSO employer, it's not automatic. If the employer facilitates vaccinations, and the more we've talked about this, the more scenarios I've been able to imagine.
So in this one, Mike, we have a lot of clients that are looking into bringing somebody on their site, hiring an outside provider that sets up, an inoculation area where where they can help facilitate that process. I don't know if that kind of changes, that scenario changes any of your conclusions, but I think we're going to see a lot of that.
Yeah. Well, I'd say that, look, that's the employer facilitating a vaccination, no doubt about it. In fact, they're bringing someone on site, right? So is there a causal link between the employment and the vaccination?
Yeah.
I think so.
Yeah. Even though it's not required, it's still voluntary, but they've got that on-site clinic kind of set up.
Sure. Yeah. Yeah. I mean, it's not dead set in stone, but my feeling is that given the way the law has been characterized so far in the case law, that's probably, a good case could be made that that's a work-related injury.
Can an employer have the employee sign a waiver?
Well, here's the thing. You can't waive workers' comp, right? You can't waive workers' comp. Otherwise, employers would do it all the time.
Right.
They do it for everybody before they even came to work there. So the answer is a big no on that one. What if they say, okay, well, you can have the day off work, or I'm going to reimburse you for the vaccination, or I'm going to pay for the vaccination. Or I would like, the receptionist is going to call the clinic and set up appointments for anyone who asks. Right. I can see that happening. What if you get the day off of work for your vaccination, or time off work for a vaccination, or you get sick, like Erica's saying, seems like they need a sick day because you get symptoms for 24, 48 hours. Now, if the employer provides you with that, is that going to be a work-related situation?
So is that an unknown, or is that it's more likely to be work-related if the employer gives you time off, pays for you to go have the vaccine, gives you time off if you have a reaction, or gives you a couple extra sick days just because you went and had the vaccine? Does that make it more likely to be compensable?
Yeah, we talked a little bit about this before we got on, and I suggested, and I stay out of workers' comp. I know enough to be dangerous, and what I've learned from Mike in our hundreds of webinars together. But from an employment law perspective, offering a type of sick pay, right? Saying for all those employees that do go out and get a vaccine, and it's anticipated that there's, 1 or 2 days of flu-like symptoms, we'll give you, an extra 2 paid sick days, if it's vaccine related. From an employment law perspective, that's, permissible if it's, evenly applied to all of your employees, right? And it's opt-in, opt-out, that kind of thing. But what does that mean if there's nothing else in their policies about mandating it or suggesting it or requiring it? What does that mean from a workers' comp if that's a work-related injury, if something happens when they take that time off and go and get vaccinated?
Yeah, I would, from a workers' comp perspective, I would draw the distinction between someone being allowed to use their normal sick pay or PTO,
Right.
and somebody who gets an extra day off work that they otherwise would not have gotten because they're getting a vaccine, right? If it's like there are employers that have created special extra days off. I've seen this with you, Christine, some of your clients. They say you get an extra 2 weeks off if it's related to COVID. And if they say, okay, you get this extra day off, it's independent of your normal sick leave because of this COVID thing. I think in that case, you're facilitating it, right? But the distinction is between employers that are doing something to facilitate it and just employers that are living in a world where people get vaccinations.
Would an employer be facilitating it or encouraging it in that scenario? If you're offering a couple extra days to get to encourage people to get vaccinated.
Yeah, my judgment right now would be yes. You've given them something to help them get a vaccine, and that inures to your benefit. It's compensable if they get injured. But if you just say, look, everyone, I think it's great if you want to get a vaccine, you have sick days to use. If you do that, if you need them, I don't think that would be an employer facilitating or encouraging vaccination such that there's a causal link between the employment and the vaccination. Right. People in our society are getting vaccines.
Yeah.
It doesn't
mean
that right.
Yeah, that right exists regardless of what the employer says. If somebody's sick, they get to use their sick pay regardless of what it's related to.
Yeah.
The employer doesn't have to say anything on that.
So the less employer involvement, the less employer direct benefit, the less employer facilitates, the less likely it's going to be work related if there's an injury. So if it's not, I think if you just got some pamphlets about where people can get vaccinations and provided it to the employees, I don't know if that would be enough to cause it to be work related or not. If you're just providing information, like I said, even if you had if you allowed your secretaries to make calls at the requests of people in the organization to set appointments, if they normally set appointments for people, that might not be enough either to connect them. But I have a distinct feeling that we're going to see some litigation around this.
Yeah,
for the next 5 to 10 years. Yeah.
And that's why we're grappling and going back to the drawing board and struggling is, almost all of this is first generation issues. A lot of time in our practices, before all of this, we relied on, lots of precedent and history and cases. And, with most of this, we don't have that. We have to, use our best judgment with what we know to go forward.
Yeah. Yeah. It's tough. We don't know. I mean, we can give general ideas and we can give percentages and probabilities, but we're operating in a world without certainty.
Yep. And sometimes we get, a government organization like EEOC to give us some guidelines, but usually those guidelines are absolutely terrible and doesn't really help us at all anyway. So
as we'll see in a minute on yours, we wanted to talk about the exclusive remedy rule because I thought, hey, you know what? It's not such a bad thing for employers if it's work related, because the whole point of workers' compensation, it's a grand bargain, as they say, right? So the applicant, if you get injured at work, regardless of fault, regardless of whether your employer was negligent or not, you get workers' comp benefits. But the employer doesn't have to deal with the civil filings. If you have a work-related injury, you can't file in civil court, right? With some exceptions. So that helps. It's a bargain. The employer gets protection from civil lawsuits in regards even to its own negligence. The employee gets benefits. So I think for most employers, you'd want to encourage it to be workers' comp. I mean, it might be a good idea for you to help people schedule or give people time off or whatever, because it brings it in within workers' comp. But that's only if the employer is the one who could somehow be negligent and be sued for that negligence. So I'm thinking about situations where the employer, the nurses, they inoculate someone who's allergic something out of school, right? So if you're an employer and you're actually doing inoculations, then you're going to want it to be work related, I would think. So, I mean, there are exceptions to the exclusive remedy rule, like sexual harassment. You know, if you sexually harass somebody, then they can sue you in workers' comp and they can sue you in civil court. A direct assault, I come up and I punch my employee in the face. Well, I can't hide behind workers' comp. That's an exception to the exclusive remedy rule. Medical malpractice doesn't fall under the exclusive remedy rule. So if you're injured and the doctor treats you and it's a compensable consequence, yes, it's work related, but you can also sue the doctor. Although there's limitations on double recovery. What came up with us is this idea of dual capacity. So I just mentioned the nurse gives a shot. There is this concept of dual capacity in workers' comp under the exclusive remedy rule. And again, I kind of had to dust off that section of Sullivan on comp because you don't see it that often. Dual capacity is the idea that a person can be operating both as an employer and as a medical provider. At least in this context, there's different types of dual capacity, but in regards to inoculation, you might be a medical provider. And so the school nurse doesn't look at the file and doesn't see that there's an allergic reaction possible here. She just inoculates. She's negligent. And then the child, and then co-employee, not the child, because that's different, right? Not the student, because they're not employees, but she inoculates a teacher. And then the teacher gets really injured and says, I don't want to just be in workers' comp. I want to sue the school district in civil court. And you say, no, because it's work related. We just talked about that. And it says, no, the exclusive remedy rule doesn't apply because of dual capacity. You weren't just acting as an employee of the district. You're acting as a medical professional. I can sue you, the school district, in dual capacity. And this was a big problem in workers' comp when it was first created. There's a lot of history here. In 1982, they passed a bunch of laws to stop dual capacity because people are getting away with suing in civil court. That was the point of workers' comp. But today, in today's environment, there's been some development in the law, and it's difficult to establish dual capacity. And you can read all about it. And at the bottom here, Sullivan Comp 2.22, if you really are academically interested.
So Mike, going back to your example with that school nurse, just to be kind of clear for myself and the audience, would that scenario fall under the exclusive remedy then, where that nurse inoculates and something went wrong? That would still be exclusive remedy.
Well, yes, on the face of it, because it'd be a work related thing, right? The employer gave you the inoculation, you got sick, it's work related. Okay. So anytime it's work related and it's workers' comp, exclusive remedy applies. No civil lawsuits are allowed. But there's this problem with dual capacity.
Mm-hmm. And I know Eric's going to maybe touch on the medical confidentiality, because that's another question that we get if the employer is administering the vaccine, to co-employees, the nurse to their fellow employees, what medical information are they allowed to have from that employee without, overstepping HIPAA or other medical confidentiality laws?
Yeah,
right. We're going to talk about that one in just a sec. Let me finish this distinction though. If the way it works here is if the employer provider, I call them employer provider, provides care that results in an injury, exclusive remedy applies. It's only when the employer provider provides care after an injury that there can still be dual capacity. So if you're a doctor and your person gets injured and they come in and treat with you after a work-related injury, then it's dual capacity. For inoculations, dual capacity would not apply. Exclusive remedy would apply, and there could be no civil lawsuit against the employer. So as an example, there's this case of Lander versus Vaca Valley Hospital, which mandated a vaccination after exposure to hepatitis, and it resulted in injury. And the injury occurred at work. It was the care that the initial care that provided for the initial injury. Therefore, dual capacity did not apply. Exclusive remedy did apply, and the applicant could not sue in civil court.
So in these scenarios, Mike, and I think Christine mentioned two, one is, these school nurses are inoculating other employees. And from this, what you've, told us here, that is a workers' comp exclusivity issue. The employee, if something goes wrong or the nurse did it badly, in some way or negligently in some way is
Uh,
still covered under this exclusive remedy umbrella, the nurse included, right?
yes. Mhm.
Now, this other scenario I'm wondering about is what Christine mentioned, that I think you said the county was recruiting some of these school nurses to help with the public in general.
I think
Uh,
that could happen, or where the county is just encouraging school districts to use their nurses to inoculate their employees.
Okay, because if it was, you know, if they did get to the point where they are basically volunteering for the public, these nurses, school nurses, are volunteering to the public to inoculate to get that vaccine out. Um, you know, given my limited, knowledge of workers' comp, that wouldn't necessarily protect them in that scenario, would it?
Right. Right. And the counties
Because these are employees.
can and have, recruited, school nurses to help with, inoculation. So I think as the vaccines ramp up, if we're in short supply of getting these vaccinations administered, I can see the scenario where the county will recruit those school nurses to assist with the general public.
Yeah.
If
And
there was an outside group of nurses, they could be sued in civil court because they're not employees of the employer. They're agents of the employer, but it's like any doctor giving any treatment out in the world. They
right.
could be sued malpractice, even if it is workers' comp. It's just the employer that's protected by workers' comp.
So in that scenario, maybe, once they cross it, and this, I don't want to get too far astray, is having an indemnity defense agreement with the county for those nurses and the school if they get more deeply involved. If something happens. That's
If they
probably
can put them under the workers' comp umbrella, yeah.
Eric.
Eric, I've been talking too much. I only left you 10 minutes for your slides.
I have 10 minutes. Okay, great. That's more than you usually give me. So,
Can employers mandate vaccines is a question.
okay. So, let me try and fit this in 10 minutes. Overarching theme is that, and I kind of hinted at it earlier, is we don't have fantastic guidance on whether or not you can mandate vaccines. As Christine mentioned, and as I am also seeing in California, I haven't seen any private or public entity mandating a vaccine yet, for good reason, because there's such a lack of guidance. Now, what we do have is some statement from the Equal Employment Opportunity Commission. Those of you who don't know what that is, it's the federal organization that deals with harassment, discrimination, age discrimination, disability issues. The California variety of that is called the Department of Fair Employment and Housing. So EEOC came out with a list of guidance that did not specifically say, employers, you may, as a matter of law, mandate the COVID-19 vaccine. That's not in there. But what is in there is our statements and Q&As that say, hey, employer, if you do mandate the vaccine, these are a few things that you absolutely must do, which are
that implies that the employers are allowed to do it, because there wouldn't be things that they had to do unless
Sure.
they were allowed to do it.
And I agree with you. By implication, they're saying it's okay. By implication.
Employers can do it.
By implication.
Yeah.
And the important note there also is we are in California, which the umbrella that we have is not just the EEOC, but it's the Department of Fair Employment and Housing, which, as everybody knows, working in California is much more restrictive than any federal component. It's California, and they haven't chimed in on this at all. But getting back to what the EEOC tells us, just so we know what we have, they say if you do this, employer, and we're implying, as Mike said, that you can, you must make exceptions for reasonable accommodations for disability, medical condition issues. You must make exceptions for sincerely held religious beliefs. So what does that mean? It means if you go to the point of saying, hey, you're not coming back to work until you're vaccinated. Okay. We already know from what Mike told us, we're in a workers' comp arena. But what do we have to do if we do that? If an employee comes to you and says, hey, I have a pre-existing condition, I can't get this vaccine, I'm at risk, I'm trying to get pregnant, I don't know, whether or not I can do this, I am pregnant. You have to make accommodations for that, which the EEOC suggests is maybe putting them in a different place in the office, maybe teleworking. And it also suggests if you, after all of this, you can't find a reasonable accommodation, it suggests you may exclude them from the workplace. And they follow that with saying, but that doesn't necessarily mean termination.
So Eric, in that scenario, could that mean an unpaid leave of absence if somebody has exhausted all their available leaves?
If it's all, and if it has all been exhausted already, it would probably fall under one of the protected types of leave, at least for a period of time.
So like FMLA, something
Right.
like that?
Yep. And I mentioned this undue hardship on the slide, just so you know, even, outside all of these new issues we're dealing with, reaching undue hardship in California is a very high bar. So it's a very difficult bar to reach. Probably so here as well. The employer is really going to have to, what we call, engage in the interactive process, really be creative in trying to find ways around this if they have determined that they have to mandate this because it's a direct threat to their employees, clients, customers, etc. So this guidance is out there, but I want to get to the scenarios we were talking about before of the nurse pre-screening, right? To give a vaccine, you're going to have to do certain things to give the vaccine. You have to have some medical history. Now, employers, typically, you do not want that information because it opens you up to all sorts of ADA issues. Now, if you have this nurse that's doing that, she's, by implication, going to have to ask some, pre-screen questions. What the EEOC tells us is, hey, if you do that, that does fall under ADA types of laws. You have to protect that information. It is medically confidential information. Obviously, what information comes out of that should not be shared with the employer in general. It should be kept in a confidential medical file that people don't normally have access to. And they also say that certainly you should not be asking genetic information types of questions unless necessary. That falls under a law called GINA, which is Genetic Information Non-Discrimination Act. And the EEOC has some specific guidance there as to why that pre-screening should probably keep that information out unless it's determined necessary to give a vaccine. So that's generally what we know about it. What the advice we've been giving to most employers, what they seem to be doing is, hey, hold on for a little bit. This just came out. There's a lot we don't know. Putting a policy in place where nobody's going to come back unless they're vaccinated, I think it's probably too soon to even consider that right now, especially with the availability.
Aren't you negligent if you don't ask some fundamental questions before you vaccinate somebody?
Well, I would assume so. It's, I don't know what questions have to be asked to administer this vaccine.
Are you allergic to vaccine? Do you have any
allergies, right? Do you have
any comorbidities that might be a vaccination might affect? I would think you'd have to ask this under,
right.
Otherwise, if there's an adverse reaction, hey, you didn't even ask anything.
No, you have to.
I'm going to sue you.
And I'm certain the nurse must do that. I expect there's some type of guidance with when you get these vaccines of what questions need to be asked. But when you as the employer are now doing this, your nurse is your employee. Now you as the employer are getting this information, this pre-screening information you normally would not be.
So what you're saying is if you have to ask, you have to ask. But when you get that information, now you're falling under ADA.
Yes.
Yeah. So you have to now, if there's a disability or perceived one, then you're going to have to accommodate that.
Right.
You don't want to know. You don't want to ask anything you don't have to.
Employers do not want to know about these, pre-existing conditions, because what happens is once they know about it and something happens, a termination, whatever it might be, the employee has an argument. Well, you didn't write me up. You didn't fire me until you got all this information about my medical history, right? Mm-hmm. That's why you actually fired me. You're worried about exposure later. And you're discriminating against me because I had cancer or whatever it might be. So this is the kind of information an employer does not want. And if you are in the situation where an employee is getting it, keep that as isolated as possible. So it does, you have an argument that nobody else knew this information. Nobody else had access to this information. It was privacy protected lock with a password that only, 2 people have, right? That's going to help if you get into that scenario.
What do you think, Christine?
Gosh, I think we could keep talking about this. I mean, just hearing you talk about the, the directions from the different manufacturers, that it really makes me even think about, potential subrogation against the vaccine manufacturers if there's a severe, allergic or some kind of a reaction. But I know that's probably another topic for, webinar
point,
number 24, 25.
Yeah.
Well, look, I mean, the important thing about exclusive remedy rules, it only protects the employer. So if anyone else in the world is negligent towards somebody, there can be an action. And if the employer is liable, subrogation can apply.
Interesting.
Yeah. I mean, so you got to remember your outside vaccinators, non-employer vaccinators, if they're hired or retained or recruited or even put on site, they're not protected. The manufacturers of the vaccine are not protected if they're negligent. The administrator is not protected unless they're an employer and giving their own employees vaccinations.
And just one last wage and hour note out there for those who get to the point where they are mandating it for whatever reason they see fit. Once, in for a penny, in for a pound. So once you're mandating it, you are required to reimburse the employee for all the expenses associated with doing that. Mileage, right? It could be pay while they're standing in line to do this. So remember, there are wage and hour implications in there as well once you mandate it, and the time and expense the employee goes through to get to that point.
We had this last slide about more questions. We're kind of out of time, though. We could probably just go a little bit over if you guys want to address any of these. Is anything grabbing you?
Yeah, one of the things we do know from the EEOC, at least, again, the federal, not California yet, that asking for proof of vaccination is okay if it's just simply a document that says, Joe was vaccinated. It doesn't have other, medical information in there or anything like that from the general practitioner. So they at least, tell us that if we ever get to a point where we're asking for proof of vaccination.
Well, if you ask for proof of vaccination, that's the same thing as requiring it. Because if you're looking for proof, it's because you won't give them something unless you get proof, like return to work.
So you're requiring it by doing that. If you're saying, we're not letting you in until you show proof, you're under this mandating vaccine umbrella. They're saying if you're mandating this under this vaccine umbrella with the very limited information we've given you from the EEOC, in California, you're on your own, good luck. Then you can, by doing that, you can ask for that one page without getting into all the other stuff I talked about, pre-screening, angina, and all of those issues. That is, an isolated way of doing it to stay away from those issues.
Mm-hmm. Yeah, I can see that third and fourth question. That's really going to start coming up more in our practice, I think, as schools reopen and businesses reopen to the general public in terms of, requiring people to be vaccinated before they're on site, and if they can require that vaccination, and even when those vaccinations are going to be, available to that tier,
right,
of the population.
Yep.
Most of the time, employers that were requiring a vaccination aren't doing vaccinations themselves, right? So I don't know there's that much danger to an employer, because you're going to send them off. You're going to require them to show a vaccination, but you're not going to get access to their medical information. You're not going to ask any questions, right? And if they get injured, it really has nothing to do with you. Mm-hmm. Although I don't know, maybe as an employer, if they get injured at your direction, it might be workers' comp. So I think probably the biggest risk for employers that don't provide direct vaccinations is that they may end up with workers' comp claims they otherwise might not have if they just left it alone. So as an employer, I would ask myself, and I am an employer, how important is it that people be vaccinated in terms of the risks associated with my clients and the employees relative to the risk of me actually ending up with a workers' comp claim if something goes wrong with the vaccination. So it's, not that much goes on with it. There's not a very good high chance that something will go wrong with the vaccination. So I don't know, Eric, I'm thinking maybe if I'm an employer, like a dentist, like I talked about at the beginning, I might mandate it. It's like, you want to come back to work physically, you got to show vaccination, because I am risking maybe a workers' comp claim.
Right.
But I'm ensuring that people won't get it. It was probably more of a risk of workers' comp claims if people are at work and they're exposed to to COVID, which is the whole reason behind a vaccination in the first place, is less risk than being in the presence of being exposed to COVID.
And if you are that dentist that, finds that need because of a direct threat to, your patients and, other workers, this is what you rely on, is this EEOC guidance that said, and probably the safest way of doing that is just requiring a proof of vaccination note that is very limited. So you're not buying into all these pre-screening issues. And you understand that, people can make ADA accommodation requests, religious belief, accommodation requests, and you have to deal with that.
Yep. We got to sign off. There's a whole lot more to talk about. If you have any further questions, you can email us, call us, have comments, let us know. We don't mind answering. I see, looking at the Q&A, we have like 54 questions already. I mean, shoot, we could have probably done this for an hour and a half. We'll never run out, but we'll never run out of questions. Anyway, I want to thank you, Christine and Eric, for coming on, and
Thank
everyone
you
for listening.
Yeah, thank you. Thanks for all your guys' help getting these questions answered. We appreciate it.
Yeah,
Yep.
we'll keep at it.
I'll keep
All the
sending them
love.
your way.
Great.
Thanks a lot. folks.
Bye.
Thanks, everybody. Take care.